I am appearing before you with another part of procedure for amendment in the series of our Indian Constitution. It is clear from the above that the amending process prescribed by our Constitution has certain distinctive features as compared with the corresponding provisions in the leading constitutions of the world. The procedure for amendment must be classed as rigid insofar as it requires a special majority and in some cases a special procedure for amendment as compared with the procedure prescribed for ordinary legislation. But the procedure is not as complicated or difficult as in the USA or in any other rigid constitution. Subject to the special procedure laid down in Article 368, our Constitution vests constituent power upon the ordinary legislature of the Union, that is the Parliament, of course acting by a special majority. And there is no separate body for amending the Constitution as exists in some other constitution, as for example Constitutional Convention. The state legislature cannot initiate any bill or proposal for amendment of the Constitution. The only mode of initiating a proposal for amendment is to introduce a bill in either house of the Union Parliament. Subject to the provision of Article 368, Constitution amendment bills are to be passed by the Parliament in the same way as ordinary bills. In other words, they may be initiated in either house and may be amended like other bills, subject to the majority required by Article 368, but for the special majority prescribed, they must be passed by both the houses like any other bill. It would be pointed out in this context that there is another important point on which the passage of the Constitution amendment bill differs from the procedure relating to the passage of a bill for ordinary legislation. Article 108 provides that if there is a disagreement between the two houses of Parliament regarding the passage of bill, the deadlock may be solved by the joint session of the two houses. But it is clear from the Article 108(1) that the procedure for joint session is applicable only to bills for ordinary legislation which come under Chapter 2 of Part 5 of the Constitution, and not to bills for amendment of the Constitution, which are governed by the self-contained procedure contained in Article 368(2). The requirement of the special majority in both houses in Article 368(2) would have been nugatory had the provision as to joint session been available in this sphere. The previous sanction of the President is not required for introducing in Parliament any bill for amendment of the Constitution. The requirement relating to ratification by the state legislatures is more liberal than the corresponding provisions in the American Constitution. While the latter requires ratification by not less than 3/4 of the states, under our Constitution ratification by not less than half of them suffices. In the case of ordinary bill governed by Article 111, when the bill, after being passed by both houses of Parliament, is represented to the assent therefrom, in the latter case, the bill cannot become an act. But the amendment of Article 368 in 1971 has made it obligatory for the President to give his assent to a bill for amendment of the Constitution when it is presented to him after its passage by the legislature. In short, though the formality of President's assent has been retained in the case of an amendment of the Constitution in order to signify the date when the amendment will become operative as part of the Constitution, the President's power to veto a bill for amendment of the Constitution has been taken away by substituting the words "shall give his assent" in Clause 2 of Article 368 as it stands after the Constitution 24th Amendment Act Act 1971. There has been a historical controversy as to whether an amendment of the Constitution made in the manner provided for under Article 368 must have to conform to the requirements of Article 13(2) as defined in Clause 3 of Article 13, or in other words, whether a Constitution Amendment Act would be void if it seeks to take away or is consistent with a fundamental right enumerated in Part 3 of the Constitution. Until the case of Golaknath, the Supreme Court has been holding that no part of our Constitution was unamendable, and the Parliament might, by passing a Constitution Amendment Act in compliance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. It was held that law in Article 13(2) referred to ordinary legislation made by Parliament as a legislative body and would not include an amendment of the Constitution which was passed by the Parliament in its constituent capacity. But in Golaknath's case, a majority of 6 judges in a special bench of 11 overruled the previous decisions and took the view that though there is no express exception from the ambit of Article 368, the fundamental rights included in Part 3 of the Constitution cannot by their very nature be subject to the process of amendment provided for in Article 368, and that if any such rights is to be amended, a new constituent assembly must be convened for making a new constitution or radically changing it. The majority in Golaknath's case rested its conclusion on the view that power to amend the constitution was also a legislative power conferred by Article 245 by the Constitution, so that a Constitution Amendment Act was also a law within the purview of Article 13(2). After the Golaknath's decision, Parliament sought to supersede it by amending Article 368 itself by the Constitution 24th Amendment Act 1971, as a result of which an amendment of Constitution passed in accordance with Article 368 will not be law within the meaning of Article 13, and the validity of Constitution Amendment Act shall not be open to question on the ground that it takes away the effects or fundamental right Article 368(3). Even after this specific amendment of the Constitution, the controversy before the Supreme Court did not cease, because the validity of the 24th Constitution Amendment Act itself was challenged in a case from Kerala, Keswanand versus State of Kerala, which was heard by full bench of 13 judges. The majority of full court upheld the validity of the 24th Amendment and overruled the case of Golaknath. The question that thus been settled in favor of the view that a Constitution Amendment Act passed by Parliament is not law within the meaning of Article 13, the majority in Keswanand's case upheld the validity of Clause 4 of Article 14 and in a corresponding provision in Article 368(3), which has been inserted by the Constitution 24th Amendment Act 1971, and reads as follows: nothing in this article, that is Article 13, shall apply to any amendment made under Article 368. In the result, fundamental rights in India can be amended by an act passed under Article 368, and the validity of a Constitution Amending Act cannot be questioned on the ground that the act invades or encroaches upon the fundamental rights. Another question which has been mooted since the case of Golaknath is whether outside Part 3 fundamental rights there is any other provision of the Constitution of India which is immune from the process of amendment in Article 368, though the majority in Keswanand's case has overturned the majority view in Golaknath that fundamental rights cannot be amended under Article 368. It has affirmed another proposition asserted by the majority in Golaknath's case, namely that there are certain basic features of the Constitution of India which cannot be altered in exercise of the power to to amend it under Article 368. If therefore a Constitution Amendment Act seeks to alter the basic structure or framework of the Constitution, the court would be entitled to annul it on the ground of ultra vires, because the word amend in Article 368 means only changes other than altering the very structure of the Constitution, which would be tantamount to meaning making a new Constitution. These basic features, without being exhaustive, are sovereignty and territorial integrity of India, the federal system, judicial review, parliamentary system of government. Applying this doctrine that judicial review is a basic feature of the Constitution of India, the majority in case one held the second part of Section 3 of Constitution 25th Amendment Act 1971 relating to Article 31 as invalid. The portion so invalidated read, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. This is all about today's part of procedure for amendment in the series of our Constitution. Thanks, regards.